Good morning, ladies and gentlemen. Thank you, Florence, for your kind introduction. I have a quite simple task today, I think, because I have to discuss, or I'm permitted to discuss with you the decision, the preliminary ruling in the case of Genentech versus Hoescht, Sanofi-Aventis. The Court of Justice of the EU ruled on that in July last year, and it's an interesting case that I will go over with you. I will first present a little bit the facts of the case and how it should be seen in time, the questions that were put to the court, and then I will discuss with you the reasoning of the court and the outcome, of course, and at the end I will look at the practical implications of that decision. So just to start with the facts of the case, it was a case between Genentech, who as a licensee in 1992 took a license under US and European patents that were held by a party called Beringwerke at the time. Later the portfolio was bought, or the activities, the company was taken over by Hoescht. And the problems between the parties started when it was Hoescht as a licensor. So the main provisions of the license, as they are known from the court decision, I did not have access to the file. The main provisions are that this concerns a worldwide non-exclusive license for a human cytomegalovirus enhancer. I will just refer to it as HCMV enhancer, that was used in the production of a biological medicinal product containing rituximab. Genentech markets that product in the US and in Europe, and as I said, there were both US and EU patents, European patents. Now, the interesting thing is that the agreement was entered into in 1992, but in 1999 the European patent was revoked. The agreement continued, and in the US the patent was contested as well, and it was also argued on non-infringement, in the sense that Genentech argued it did not infringe the patents. Well, both these issues were argued in the US, and both actions were dismissed. So in the US, the patents were valid, but not infringed. And in Europe, in 1992, the patents were revoked. So that is the scene against which this all took place. Now, the license contained three forms of payment for Genentech: a lump sum payment at the beginning of the lifetime of this license, annual research fee, and also further royalty to be paid for finished products. The license was subject to German law, and there was an arbitration clause. I think that's all we need to know to continue. Here I've put a timeline. I don't know whether it's properly visible on this on the slide, but here I sort of sum up what I've just discussed. When the license was entered into in 1992, and the upper portion is what happened in the EU, and below the arrow is the US litigation. Now, parties at some point in time got a discussion on whether Genentech was obliged to pay the running fees on finished products. That first was raised by Sanofi in 2008, and when that point was raised, because Genentech never paid those fees, Genentech reacted by terminating the license agreement, and from then onwards arbitration started, and that ended, it led to a third partial award by the arbitrator, in which the arbitrator held that Genentech was still obliged to pay the royalty fees, which it had never paid, despite the fact that the patents in Europe had been revoked. So the arbitrator apparently found that Genentech was able to terminate the agreement and on within a reasonable notice, and found that according to German law, this was justified and Genentech was to pay. Now, from that arbitration award, all kinds of litigation came. It was contested by Genentech before the Court of Appeal in Paris, asking for an annulment, whereas the other side wanted to enforce the award of the arbitrator and have Genentech pay for the license. The Court of Appeal, the Paris Court of Appeal, found reason to refer the case to the Court of Justice, asking for a preliminary ruling, and this was framed as follows. Must the provisions of Article 101 be interpreted as precluding effect being given, where patents are revoked, to a license agreement which requires the licensee to pay royalties for sole use of the rights attached to the licensed patent? That was the question put to the Court of Justice. In paragraph 34 of its decision, the Court of Justice extends the scope of this question by stating that that question should be understood as also referring to the case of non-infringement of the licensed patents. So the question for the court is there an obligation to pay, is the obligation to pay royalties in a situation where the patent is revoked or invalid, or actually non-infringed? Is such an obligation to continue to pay in violation with Article 101? There was quite a discussion between the parties about the admissibility of this preliminary ruling. That is not the core of the decision, I think, for this audience, but it's interesting to just go over the arguments brought by Hoescht and Sanofi regarding the inadmissibility of this preliminary ruling. So I will just quickly address what the Court of Justice observed in this respect. So with regard to the arguments on inadmissibility that were all rejected by the Court of Justice, it ruled as follows. The court said it must abide by the decision from a court of a member state requesting a preliminary ruling insofar as that decision has not been overturned in any appeal proceedings provided by national law. The issue was raised. The issue was raised that in this particular case, the Court of Appeal of Paris was not entitled to refer the case to the Court of Justice, and the Court of Justice said it's not up to the Court of Justice to decide whether the Court of Appeal was justified referring the case to us. It is national law that decides it. So in this particular case, an appeal was made to the Supreme Court, the Cour de Cassation, and that cassation court ruled that the reference to the Court of Justice was entitled. And then another issue raised was the question whether this reference was relevant or irrelevant for the outcome of the case. The Court of Justice held that since the referring court raises the question whether Article 101 precludes the license agreement from being implemented in accordance with the interpretation given to it by the arbitrator, the question as to the interpretation of Article 101 is not irrelevant for the purpose of resolving the dispute. So that point was also done away with. And then in respect of the argument that the Court of Justice does not have all the facts to decide this case and to give a ruling, the court observed that the referring court had adequately defined the factual and legal framework within which it made its request for interpretation of EU law, which enabled the Court of Justice to provide a useful reply. And it also observed that the referring court has formulated its questions as referring to a particular situation in which the licensee would be required to pay royalties for the use of rights attached to the patent, notwithstanding the revocation of those patents. The referring court is aware that US patents, the US patents, I also referred to it, which the parties agree are the only patents of relevance for the purpose of the main proceedings, have not been revoked. So all the facts were there, and the Court of Justice held that it was perfectly able to give its ruling. Now, to the merits, dealing with the actual question that was put before the court. The court referred to an old decision, the decision of Ottung. That is a decision from 1998. No, 1989, sorry. And the Ottung case, Ottung-Clay case, it's fully referred to. In that case, a pretty similar situation occurred. There are differences, I'll come to that. And the Court of Justice says it should be further recalled that the court has already ruled in the context of an exclusive license, this was a non-exclusive license, in the context of an exclusive license, that the obligation to pay a royalty, even after the expiry of the period of validity of the licensed patent, may reflect a commercial assessment of the value to be attributed to the possibility of exploitation granted by the license agreement, especially when that obligation to pay was embodied in a license agreement entered into before the patent was granted. That was the ruling in the Ottung case. And in such circumstances where the licensee may freely terminate the agreement by giving reasonable notice, an obligation to pay royalty throughout the validity of the agreement cannot come within the scope of the prohibition set out in Article 101. So, that being there, the Court of Justice then examined whether the ruling in Ottung could still be applied or could be applied to the present situation. And the Court of Justice ruled that it follows from the judgment of Ottung that Article 101 does not prohibit the imposition of a contractual requirement providing for payment of a royalty for the exclusive use of a technology that is no longer covered by patent, on the condition, however, on the condition that the licensee is free to terminate the contract. That assessment is based on the finding that that royalty is the price to be paid for commercial exploitation. I highlighted that also from the Ottung case. That's the price to be paid for commercial exploitation of the licensed technology with the guarantee that the licensor will not exercise its industrial property rights. And as long as the license agreement at issue is still valid, the agreement is still valid, and can be freely terminated by the licensee, the royalty payment is due, even if the industrial property rights derived from patents which are granted exclusively cannot be used against the licensee due to the fact that the period of their validity has expired. And then the Court of Justice continues that in light of such circumstances, in particular the fact that the license may be freely terminated by the licensee, the contention may be rejected that the payment of royalties undermines competition by restricting the freedom of action of the licensee or by causing market foreclosure effects. So, to conclude, the solution stemming from Ottung is, according to the Court of Justice, still valid, applies a fortiori in a situation such as the one in the present proceedings. If, during the period in which the license agreement is in effect, the payment of royalty is still due, even after the expiration of industrial property rights, the same applies a fortiori before the validity of those rights has expired. According to the Court of Justice, Article 101 must be interpreted as not precluding the imposition on the licensee under a license agreement, such as that one in issue in the main proceedings, of a requirement to pay a royalty for the use of the patented technology for the entire period in which the agreement was in effect, in the event of the revocation or non-infringement of a licensed patent, provided that the licensee was able freely to terminate the agreement by giving reasonable notice. So I think that the decisive factor is in the last bit of that decision, as long as the licensee has the possibility to terminate the agreement. Now, it's interesting to observe what kind of practical, before I observe and go to the practical implications, it's maybe interesting to note that this decision is also in line with the Commission's rules on the Commission's European Commission's technology transfer guidelines, because in Article 100 paragraph 187, it's stated that parties can agree to extend royalty obligations beyond period of validity of licensed IPR without violating Article 101. So also that is in line with this ruling. It is, however, remarkable that in the US, this is quite different. I can refer to two cases that pop up when you look for this topic. A very old case, the so-called Brulot case. It's Brulot-Thijs, decision of the Supreme Court in 1964. That was based on patent law considerations, and in a comparable situation led to the conclusion that continued royalty payments are in violation of patent law and therefore not allowed. And this similar type of situation occurred 50 years later, or almost 50 years later, in the case Kimball versus Marvel. That case was purely decided on antitrust, and the Supreme Court confirmed that continued royalty payments after expiry of the patent rights, after the ending of the validity of the patent, was antitrust, though in the reasoning of the court you can also find observations that are more critical, showing that the court realizes that there are commercial considerations for continuing the royalty payment over a longer period past the patent validity term. But the court held that it was, the court determined it was bound to the rule of precedent, and that's why apparently the Supreme Court did not deviate from it. Now, let's turn to some practical implications, and if I say that I do realize the practical implications of the Genentech case will differ from which standpoint you take, if you are the licensor or if you are the licensee, if your market is in the EU or if your market is in the US, or even if your market is in both areas. So there is not a rule here to give that fits everybody, but I just give you some of my observations. So in any case, it is a learning lesson in drafting a license contract that you, whether you're from the licensor or licensee perspective, you give it a good thought how you want to accommodate a situation like this. Do you, as a licensor, give more than the assurance that you will not, litigate for infringement against the licensee, or do you give other technical know-how? Is there more involved than just the patent right, that is the license under the patent? And on the other hand, the licensee also has to see whether it needs to incorporate in the license some provisions that protect it against continued obligations if the patent is no longer valid. So I think that a licensee should ensure that the agreement, or at least the payment of royalty provision, can be terminated upon expiry or revocation of the patent, or in case it later turns out that what he produces does not infringe. I think it is, from the licensee perspective, important that there is a reasonable notice for termination, because that's also in the teachings of this decision of the Court of Justice. And I think it's important to put an obligation on the licensor to notify the licensee if the patent is challenged, if there are claims brought against the patent arguing that it is invalid by third parties, that the licensor has an obligation to notify the licensee thereof, maybe even secured by a penalty, because that will allow the licensee to know what's going on with the patent. And in general, I think that the licensee should monitor what is happening with the patent. So these are my observations for now. I'm happy to open the discussion with you. Thank you.